There's a major update in the legal fight to overturn suppressor bans, and it could have a ripple effect across multiple states. A key lawsuit, Morris v. Raoul, is currently underway in federal district court in Illinois. This case challenges the state's outright ban on the purchase and possession of firearm suppressors. If successful, it could become the first case in the country to dismantle these statewide bans, potentially setting the stage for similar challenges in states like California and others that prohibit NFA items such as suppressors. Right now, Illinois is attempting to get the lawsuit dismissed at an early stage. The state is asking the judge to throw it out by arguing that suppressors are not arms protected under the Second Amendment. In their view, that makes it legal for them to ban suppressors entirely. But here's where things just took a dramatic turn. In a separate federal case, United States v. Peterson, the Department of Justice under the Trump administration filed a brief that could completely undermine Illinois' argument. For the first time in a long while, the DOJ acknowledged that suppressors are protected arms under the Second Amendment. They made it clear that states cannot impose blanket bans on them. This shift in the DOJ's position is now being used as a powerful argument in the Morris v. Raoul case. The plaintiffs are pointing to this brief and saying, look, even the DOJ now admits that suppressors fall under Second Amendment protection. Illinois doesn't have a legal leg to stand on. So what does this mean? It means the entire strategy used by states like Illinois to ban suppressors is now under serious legal pressure. If the court agrees that suppressors are protected arms, then bans like this one can't stand, and we could be looking at a turning point in Second Amendment law, especially when it comes to NFA-regulated items. This is a case to watch closely. It could open the door for future challenges across the country and eventually roll back suppressor bans on a much larger scale. In the ongoing suppressor lawsuit Morris v. Raoul, we now have a clearer picture of how both sides are building their arguments, and it's shaping up to be a pivotal case for suppressor rights nationwide. The plaintiffs are making it very clear, suppressors are not dangerous and unusual items, and ownership of them doesn't fall into that category either. Instead, they argue that suppressors are commonly owned by law-abiding citizens for lawful purposes, like protecting hearing, reducing noise pollution, and improving safety at the range. In their view, that makes suppressors protected arms under the Second Amendment. But the state of Illinois strongly disagrees. Recently, Illinois filed a motion for judgment on the pleadings, essentially asking the court to toss out the case before it really gets started. Their argument is based on the idea that suppressors aren't actually arms under the meaning of the Constitution. According to the state's filing, the Second Amendment protects the right to keep and bear arms, but suppressors, they claim, don't qualify. They argue that silencers aren't weapons, they're not used in self-defense, and they're not necessary for a firearm to work properly. Therefore, Illinois says, they shouldn't be considered arms in the constitutional sense, and the lawsuit should be dismissed. Illinois goes further by referencing historical definitions, saying that even if a device didn't exist at the founding, it still must meet the original concept of what qualifies as an arm. They claim a silencer doesn't fit that definition. It doesn't shoot or project anything, it doesn't load or feed ammunition, and it doesn't inherently serve a self-defense function. Even if some people find suppressors helpful, Illinois insists they aren't essential to firearms use and therefore fall outside of Second Amendment protections. Essentially, the state's main argument is this: a suppressor is just an accessory, not a weapon, not a firearm, and not something that can be borne in the legal sense. Because of that, they believe it doesn't get Second Amendment protection. But here's where their argument runs into problems. At the federal level under the National Firearms Act, NFA, suppressors are classified as firearms. That means, legally speaking, the federal government treats suppressors as firearms for purposes of regulation, registration, and taxation, the very thing Illinois says they're not. It's a direct contradiction. As for the court proceedings, there was a recent motion hearing scheduled in this case, but things were temporarily paused. That's because other legal challenges are currently underway in Illinois involving the state's rifle and magazine bans. Specifically, lawsuits challenging the PICA law. The judge overseeing the suppressor case decided to place things on hold while those related cases play out, likely because the outcomes could impact how this one moves forward. So for now, we're in a waiting phase, but this case is still one to watch. Depending on how the judge rules down the line, it could set a legal precedent that either strengthens or weakens the path forward for restoring suppressor rights across the country. There's been a major development in the suppressor lawsuit out of Illinois following a significant ruling in a related case. Judge McGlynn recently struck down the Illinois Protect Illinois Communities Act, PICA, including the state's bans on so-called assault rifles and standard capacity magazines, declaring both unconstitutional. That decision is now being reviewed at the 7th Circuit, but it had an immediate impact elsewhere. After that ruling, the judge in the Morris v. Raoul suppressor case decided to reopen proceedings and allow the lawsuit to move forward. A hearing on the motion was held shortly after the case resumed. In response, the state of Illinois submitted a supplemental notice referencing a separate legal case, U.S. v. Peterson, claiming it was relevant to the suppressor case at hand. For those unfamiliar, the Peterson case centers around a man whose home-based gun store was raided by the ATF. During that raid, agents discovered a solvent trap, a device that can be easily converted into a suppressor, which was unregistered and unserialized. Peterson was charged with violating the National Firearms Act, NFA, and he responded by challenging the constitutionality of the NFA under the Second Amendment. Initially, the district court rejected Peterson's argument, stating that suppressors are not bearable arms protected under the Second Amendment. That decision was then taken to the Fifth Circuit Court of Appeals, where a 3-judge panel also ruled against Peterson and upheld the federal government's position. At the time, the Biden administration maintained that suppressors are not protected arms. Their stance was that suppressors are merely accessories, not weapons, and are not essential to the operation or function of a firearm. Therefore, they argued, suppressors do not fall under the protection of the Second Amendment. This legal theory was heavily cited by Illinois in their motion to dismiss the suppressor lawsuit. They leaned on both the District and Fifth Circuit decisions in the Peterson case to argue that suppressors are not constitutionally protected. However, the situation has since changed. Under the current Trump-appointed DOJ leadership, there's been a major policy shift. The DOJ has now reversed course in the same Peterson case and acknowledged that suppressors are indeed protected arms under the Second Amendment. They further stated that states cannot impose outright bans on suppressors, a position that undermines much of the state of Illinois' argument in Morris v. Raoul. This policy reversal could prove significant. While the courts in the Peterson case originally ruled against suppressor protections, the federal government's stance is now evolving. The DOJ's updated position is already being used by the plaintiffs in the Illinois case to challenge the legitimacy of the state's arguments. With the Morris case now back in motion, and with conflicting interpretations between circuit courts and shifting federal policies, this lawsuit could set a new precedent for suppressor rights across the country, especially in states that currently enforce outright bans. In a recent brief filed in the Peterson case, the Department of Justice made a significant shift in its position. The DOJ now explicitly states that, in the view of the United States, the Second Amendment protects firearm accessories and components, including suppressors. Based on that, they argue that restrictions on suppressor ownership burden the constitutional right to keep and bear arms, and that a complete ban on suppressors or similar accessories would be unconstitutional. They also admitted that their previous position was incorrect. This change puts Illinois in a difficult position. The state had relied heavily on the DOJ's prior argument, the one that claimed suppressors weren't protected under the Second Amendment. Now that the federal government has reversed that stance, it undermines a key part of Illinois' case. The plaintiffs in the Illinois suppressor lawsuit quickly responded to this development. They submitted a new filing to the court, highlighting the DOJ's updated position. In their filing, they pointed out that on May 23, 2025, the Department of Justice stated that suppressors support the constitutional right to bear arms, and that restricting them creates a burden on firearm use that implicates the Second Amendment. The DOJ also made it clear that an outright ban on suppressors would be unconstitutional. This reversal from the federal government isn't just affecting the Peterson case. It's now becoming a central issue in the suppressor challenge in Illinois. The DOJ's updated position may carry significant weight in court, especially as the plaintiffs argue that the state's suppressor ban should be struck down. Now it's up to the judge to weigh this new information. With the federal government acknowledging that bans on suppressors go against the Constitution, It will be important to see how the judge interprets that in the context of Illinois law. There's a lot riding on this, and the outcome could have broader implications for suppressor regulations across the country. We'll be watching this case closely, and I'll keep you updated as it moves forward. If you found this update helpful and want to support the channel, make sure to like, comment, and subscribe. It really helps get this information out and shows YouTube that this content matters to you. Thanks for watching.